Yeah, we do not need any state legislatures if you're not going to enforce the requirements of the law. And everything is going to be decided because of the precedent setting hearings of judges. Yep. And that means that it doesn't really matter. Yep. Because as long as you can say that a certain judge made a decision about a certain court case, yep, state legislatures are no longer needed. For the governors that are going to get sued, all 50 of them, yep, you're going to get sued. For the governor of the state of Washington, you're going to get sued. Yes. The Secretary of State, the oaths of office of the executive branch. Yes. The Supreme Court of Washington State is going to get sued. Yes. All of them. There's this refusal to acknowledge the legislature's decision, yes, in passing the requirements of civil law. Yeah. And you said, well, we don't have to do anything. Yeah. But the problem is you do. This is your glossary of definitions. Yes. Petition for an order for protection. Yeah. What specific act or threats of violence alleged to have occurred? Yes. After my record was expunged. Yeah. After I was found not guilty. What specific act or threat of violence has been alleged? I'm homeless. I'm homeless because I know where to eat every day. Yes. I'm homeless because I know where to get clothes. Yes. I'm homeless because you refuse to enforce your state legislature's rules, laws, statutes, procedures, and regulations. Now, you would have thought that you could have arrested somebody. You would have thought that, yep. And request specific relief from the court, yep. And the respondent must be served with a copy, yep, of the petition prior to the full hearing. Yes. Before the full hearing takes place, yes, the respondent must be served. Yep. Now, for some reason, there's this precedent-setting case. Yep. Auburn, Solaris, or whatever it is. Yes. But I'm almost absolutely sure that the petitioner signed the court. Almost sure. Couldn't find him. They issued it anyway. Yes. They did serve him when they did find him. Yes. Now, petitioner is the party who commences the action. Did the judge think that because you'd issued court orders that required me to have a mental health evaluation and the treatment that is required? Yes. That I had to do it because I did know that there was no specific act or threat of violence? There was no arrest. Nothing had taken place when you issued this on July 31st of 2015. Yes. The only thing that you disliked was I was homeless. Right. And when you issued a dissolution of marriage that took the custody of my sons without me getting any notice of it, yes, without me getting a copy of it, yes. The only reason that you thought that I was mentally ill was, yes. Well, you didn't serve me. You thought that I was going to go to court and I was going to pay to get a copy of my own dissolution of marriage. Yes. That there were no requirements in the RCWs of the state legislature in civil law when having a dissolution of marriage, yes, or protection orders, yes, that these requirements of law right now are not enforceable in any state of the United States. That you, in your discretion as a judge, yes, have the availability of issuing a dissolution of marriage and protection orders, all because of my wife saying I was mentally ill, without any specific act or threat of violence against her or my 5 sons. Rooch, you, the judge, right now, are more important than the legislative bodies of every state of the United